I'm AJ Skogerson, co-founder and attorney at the Law Shop by Skogerson McGinn LLC, where we help you turn the page. Today's story is from a chapter in the life of my own family. Recently, a beloved family member passed away, and we'll call this person Uncle Bill. Uncle Bill was a stand-up man in his community. He spent a lot of time with family, with his various siblings, nieces, and nephews. Bill married his twin flame, and we'll call that person Brandy. Brandy had two young children from her own prior marriage. Brandy and Bill had a beautiful marriage. Unfortunately, it was short-lived because of the fact that Brandy passed away from cancer when her youngest child, Judy, was just entering college. Bill never remarried. And after Brandy's passing, Bill and Judy did keep in close contact. They called each other, they traveled together. Judy helped Bill to manage his needs. She always made sure that he had a dog by his side, as well as access to email and video conferencing so that she could stay in touch with him. Bill and Judy had a strong parent-child relationship by anyone's standards, and everyone around them knew it. Bill was never wealthy, but he was frugal, and he was a hard worker all his life. As Bill got older, he remained close with his daughter, Judy, and he wanted to help ensure her future well-being once his own time on this earth was up. With the help of a family friend who typed things up, Bill prepared a will with instructions for distribution of his assets after death, most of which were to go to Judy. Bill also signed a deed to Judy for his home, and that home had no mortgage on it. Bill then put the signed will and deed in his safety deposit box at the bank. Less than a year later, Bill passed away suddenly from a heart attack. Bill's family, including Judy, gathered together to mourn their loss and to celebrate Bill's life and legacy. The family also retrieved the will and the deed from Bill's safety deposit box, and they delivered those documents to a local attorney to execute on Bill's last wishes. To everyone's surprise, though, the attorney advised that neither Bill's will nor the deed to Judy were valid. Although both were clearly written, the documents had not been properly executed or witnessed according to state law. Thus, Bill's estate would be treated as though he left no will or deed at all. Further, Bill's sole heirs under state law were his blood relatives, meaning a stepchild such as Judy would not be recognized, and that Bill's siblings would inherit everything, and they would have to unanimously agree on anything being given to Judy. Unfortunately, as so often happens, after the passing of a loved one, the family was not in agreement, leaving a lawsuit amongst family members as the tragic legacy of Bill's own good intentions. Now, I'd love to tell you how the story of Bill and Judy ends. I cannot, though, because frankly, it's still in litigation, where it will probably remain for at least another year or more, and where the outcome will probably leave the entire family still unhappy. So the moral of this story is simple. Don't be like Bill. Make sure you have a proper estate plan that you can count on being honored when you're unable to make decisions for yourself and when your own time on this planet is up. Otherwise, the state in which you live will end up deciding what happens to you, your belongings, and even your children if they're still minors when you pass away. At the Law Shop, we can help you turn the page with a proper estate plan. Come check out our story and learn more about how we can help with yours by visiting www.lawshop.net.